That's the idea. And one thing I didn't mention before that I should have is it's a common misconception that you need to register every single artwork. Every time you send something off, you've got to go back to the register. That's not the case. You will need a separate registration for each grantor you're dealing with. So if you're dealing with multiple galleries, there needs to be a separate registration for each one of those. And the reason for that is that people searching will only be searching on the name of that entity, right? So there needs to be a separate registration for each of those, but a registration can cover all of the artwork. So it just needs to be, as I mentioned before, like a general description. The kind of artwork is probably, going to be okay. You don't have to itemise every single thing. What will happen is that if an insolvency did occur, then one of the first jobs of the insolvency administrator will check the register. They go, okay, we've got paintings held by this person with security interests over in the name of this person, and sculptures with a security interest in the name of this other person, and then they should then do the work required to ascertain exactly what the agreement provided for and so forth. Yeah.
Isn't this the case where you have to, where the artist has to have a consignment agreement with the gallery, and each time there's a change, that consignment agreement has to change to reflect it, isn't that the case?
So the register's job is not a register of every single piece of property. It would just be totally impossible to have all that. It's a register of security agreements. So the register will know that there's a consignment agreement in place, or there's a security interest in place between the entity, the insolvent entity, and another person. And from there, that's really all the register is designed to do.
And the rest is a matter of
it raises the flag. It's like, okay, there's a flag there. And the other important thing that it does is if there are conflicting security interests or competing security interests, for example, that example before where, let's say, the gallery had an arrangement with a bank, maybe one of the big banks, and the bank had a security interest over all of its property, quite likely scenario, and that happened, years ago. Well, the register's job is it keeps a very careful record of time, and it actually records the registration time to the second, so that if there are competing claims, it's very easy to determine basically who came first. But it's not always first in time wins, because if there is a PPSA can beat something that's not a PPSA earlier in time. But it's not a register of, and this is something where lots of people find it difficult to understand, and I certainly.
Everybody doesn't understand.
It's not a register of property in the same way that let's say the motor vehicles registry down the road. You can look at that and find out, well, this is owned by this person. All it does is say, well, there's a security interest. And from there, it's a question of the liquidator would need to make investigations, and yes, you're right, it probably would involve going back to the source documents to find out exactly.
You're going to represent you as an artist.
Yeah, and record keeping. I mean, the most important record from the register's point of view is that written agreement, but then after that, keeping records of the separate deliveries is also important. And the discussion before about proceeds is relevant here. So if it was at the point in time where the work had been sold, converted to cash, and if there was a security interest in the proceeds, well then the artist would still have a security interest in that cash, and then that cash should be in an insolvency situation. That's really the point of the security interest, that you get that cash. It doesn't get distributed to the entire body of creditors. That's what the security interest is for.
So basically, you're a secured creditor in the insolvency as opposed to one who, as opposed to a non-secured creditor, basically, who then participates in what's left.
So you could put in a claim and you might be the 20th person on the list and you might get 10 cents on the dollar. I mean, that's what happens, isn't it, with everybody? Depending on where you are prioritized in that list, if you're the 5th person and there's this much money that they've actually managed to get back or call back, then you get that percentage of whatever is available where you sit in that line. And if you're the 50th creditor and there's nothing left, you get zip, right? I mean, that's kind of how it works, isn't it, for everybody?
So generally, there's a on an insolvency in a corporate context, there's kind of a priority order, and the administrator sits close to the top, and employees also close to the top. Then secured creditors, and actually, if it's a fixed security interest, which means not just saying all property. If it's all property, employees actually rank above that. But if it's a security interest over a particular property, then the secured creditor actually ranks above employees. And then the secured creditors, there's priority between secured creditors if there's more than one secured creditor over that property, and that's where the timing and the registration, that's when that becomes really important, if you've got competition between secured creditors. And that's when the discussion about a PIMSI versus a non-PIMSI comes in. And then after that, there's the general body of unsecured creditors, and that's where you get the, they just tally everything up and then divide up what's left. Everybody. So but if you're searching against, and everybody can search an organisation. So if it's a company, anybody can just get on there and search against the company at any time, no problem. But as I mentioned before, there are rules about searching against individuals, and those rules are there for privacy reasons. And so if you're searching against an individual, one of the things you need to do is declare that I'm searching for one of these authorised purposes. Well, in the ordinary course, in the sort of transaction that we've been mainly focusing on, where someone's selling on consignment or retention of title, then the secured party would be the person selling, and so they would be the person making the registration because it's their interest in the property that's being registered. And as I mentioned, when that verification statement comes back, which is the statement of details of the registration, one of the things that the Act requires the secured party to do is actually give a copy of that to the grantor, in this case the gallery, so that they can review it, and just if there is any issue with it, the registrar would always encourage the parties to just talk about it first, and so that encourages the grantors to just approach the secured party and say, I think this description's not right, or you've registered as a plant breeder's right, and I think you might have ticked the wrong box or whatever it is, and then sort it out themselves. But if not, there are processes. Ultimately, you can go to court, but before you go to court, there is a process called an amendment demand process, where if somebody puts a registration on, let's say they put a registration on where there's actually no security interest at all, you can fill in a form, send it to them demanding that they remove it. If they don't remove it, you send a form to the registrar explaining what's happened, and then the registrar gets in touch with them and says what's going on, and if they don't provide us a sufficient explanation, the registrar will get on the register and take it off. That's a very good question, and the answer is that the register is not the ultimate source of truth about what actually underlies it, because as you've seen, it's very brief. What you type in there is just a very brief description. So all it is a notice board. It's like a gigantic Sydney Morning Herald, I suppose, that says there is this security interest there, but really, if you want to find out more about what's happening, then you really need to go back to the underlying agreements themselves and all of the other documents. So just because something was on the register doesn't give anybody, the person who put it on the register, any more rights than you can't sort of concoct extra rights. I mean, the real rights are found in the agreement. That's what's really giving you the rights. What this is just a notice that those rights exist. And as I mentioned before, you know, registration can give certain priority that has priority consequences, but it doesn't. It's not a register of ownership or a register of rights. It's just a register of that the agreement exists, so that the security agreement exists. There is that capacity, but it's not a requirement. So you can attach a copy of the agreement if you want to, and in fact some of the older registers, the ASIC Company Charges Register, it used to be a requirement. So they had, their register was full of very dense, thick company charge documents. And all of those, if you do a search, you will pull all of those up and you can look at them. And if you want to, you can actually do the same now. You can upload a copy of your agreement if you want to, so that everyone can see it. But it's not a requirement. Some people prefer not to do that because it has information in there that they don't want to be available to the general public. But it is an option. And if you don't want people to be contacting you saying, you know, what is going on here, what is the relationship, you might choose, and if there's nothing particularly confidential, then sure, you might choose to just upload that. You need to scan it, obviously, and then upload it, and then anyone who does the search can find out exactly what the relationship is straight away. They don't then have to take that next step of contacting the secured party through the address for service, the email and whatever that you entered. They can see exactly what's going on.